The video unequivocally showed that during a conversation with Mr. Green, Judge Brue aggressively grabbed at the receipt that was in his hand. This evidence is undisputed. And immediately after doing that, Judge Brue turned the tables and accused Mr. Green of assaulting her.
Demetria Brue turned a $23 bike rental dispute into an assault and racism claim, and her friend swore none of it happened until video proved otherwise. There are two main problems with that. First, Brue and her friend, Debra Nance, are both Wayne County judges. Second, both judges lied under oath. So let's manage our expectations here. The result of this hearing is not yet known. The Judicial Tenure Commission will take their time coming to a decision. In the meantime, this is your chance to tell me in the comments whether you think these two judges should be kicked off the bench, or if the JTC is making mountains out of molehills. I know which way I would go. Let's roll, nerds.
The video unequivocally showed that during a conversation with Mr. Green, Judge Brue aggressively grabbed at the receipt that was in his hand. This evidence is undisputed. And immediately after doing that, Judge Brue turned the tables and accused Mr. Green of assaulting her. Despite Judge Brue alleging that she was entitled to this receipt, that Mr. Green was only to possess it, and that she thought she had the opportunity to retrieve the receipt without touching Mr. Green, this evidence is the strongest and clearest. The video demonstrates a clear lack of restraint. It demonstrates the inability to problem solve and calmly handle an unfavorable situation. The video proves that Judge Brue acted inappropriately, irrespective of her explanation of a right to retrieve possession. The second strongest piece of evidence is the lip reader testimony, to include Judge Brue's own lip reader, who extracted the same exact sentence seconds after Judge Brue grabbed the receipt from Mr. Green. Immediately after the grab, Judge Brue falsely accused Mr. Green of assaulting her, as charged in count 2 of the complaint. Each of the lip readers extracted some variation of the phrase, "You assaulted me. Did you just assault me?" Witness testimony demonstrated that Judge Brue told Mr. Green that he, a Caucasian male, had just assaulted an African-American judge and acted with violence toward her. She also accused Mr. Green of being a racist and treating she and Judge Nance unfairly because they were Black. The evidence clearly establishes that Judge Brue told Mr. Green that she was absolutely a judge. The testimony of Mr. Green reiterated that Judge Brue made statements during their conversation to include, "You are a Caucasian man, and you struck a sitting African-American female judge. Do you know what's going to happen to you, a Caucasian man that's found guilty of striking an African-American female judge?" In addition to Mr. Green, bike shop employees Scott and Libby both unequivocally testified that they heard Judge Brue tell Mr. Green that she was a judge. Judge Brue claiming that he did so was a false statement. She had spoken to Officer Hardy for more than 10 minutes to tell her version of the argument that she had with Mr. Green, including the false claim that Mr. Green had assaulted her. Judge Brue had to know that her claim that Officer Hardy did not talk with her was false when she made it. Throughout the investigation, and as part of their effort to portray themselves as the victims of racism on Mackinac Island, Judge Brue and Judge Nance falsely alleged that Officer Hardy told them to wait by the curb while he and Mr. Green watched the video. They alleged that this directive itself established that Officer Hardy was racist. In another striking similarity between their supposedly independent descriptions of the events on the island, both Judge Nance and Judge Brue claimed during the investigation that that particular phrase, "wait by the curb," had negative connotations when applied to African Americans. However, Judge Nance retreated from this narrative during the public hearing. claiming that this directive was formal and normal police procedure, a much different narrative than previously indicated. Judge Brue knew that when she was giving the distinct impression that she had not ever had any contact with the Judicial Tenure Commission, that was false. When she wrote that, she knew full well that commissioners had previously met with her to express concerns about her demeanor. The issue is candor. Respondent attempted to create the impression that the commission had no prior concerns about her conduct. That was not true. It was materially misleading. Judge Nance was standing right next to Judge Brue when Judge Brue was exclaiming that Mr. Green had assaulted her. She was standing right next to Judge Brue when Judge Brue stated that she was absolutely a judge. Judge Nance was right there. Put yourself into this situation for a moment. You're a judge. You know that judges are held to a higher standard, and you just heard your judicial colleague falsely accuse a man of assault and tell him that she was an African-American judge. Those are very inflammatory things for a judge to say. They are not things a fellow judge would easily forget. Judge Nance was insistent when she first testified, but once she was faced with the evidence that contradicted her, she retreated. She claimed that she may not have heard the reference to Judge Brue being an African-American judge. She may have turned her body away. That she may have read her own face years later and concluded that something must have been said. Her explanation evolved into a remarkable claim that in 2023 or 2024, years after her sworn denial, she watched herself on silent video and read her own facial expression to conclude that she must have heard the words African American. This commission must ask, is it credible that a judge emphatically denied under oath that her judicial colleague made a racial allegation that her colleague clearly made? Is it credible that she did so while falsely injecting race into the encounter herself? Is it credible that she maintained her denial in pleadings and only years later, and when it became clear that the evidence disproved her other claims, that she discovered the truth by studying her own facial expression on mute video? Or is it more plausible that the initial sworn denial was false? In her sworn statement, Judge Nance repeatedly volunteered that Officer Hardy refused to speak with them and would only talk to Mr. Green. She was very upset during her sworn statement that Hardy had refused to speak with them. Judge Nance was charged with lying repeatedly about whether or not Judge Nance and Judge Brue spoke with Officer Hardy. That was not a minor part of her story. Disciplinary counsel cited on pages 21 and 22 of their objections the 10 or so times that Judge Nance emphasized this false claim. Officer Hardy refused to speak to them was central to her narrative. It supported her claim that they were dismissed, that they were treated unfairly and discriminated against, that they were the victims of the interaction on Mackinac Island and not Mr. Green. Judge Brue could not have told Officer Hardy that Mr. Green assaulted her if he didn't speak to them. Judge Brue could not have told Officer Hardy that she was a judge if he didn't speak with them. But the video shows Officer Hardy speaking with Judge Nance and Judge Brue for more than 10 minutes immediately upon his arrival. He stood directly in front of them. They did the majority of the talking. Mr. Green participated occasionally and briefly. And after reviewing the video inside the shop, Officer Hardy again spoke with the judges for more than 10 minutes, explaining what he saw. Yet, Judge Nance denied that he spoke with them. That was not ambiguity. That was not weak memory. That was an entirely false narrative. When confronted with the video evidence that disproved her false narrative, Judge Nance's narrative softened. It then became, he did not fairly listen. Her initial statements were not meant to be literal, but rather colloquialisms. She was really just trying to say that Officer Hardy was dismissive. But that is not what she said under oath. Another significant shift concerns the allegation that she and Judge Brue were told to wait by the curb. During earlier stages of this case, Judge Nance portrayed the alleged command as humiliating and racially charged. It was offered as further evidence of the supposed disrespect she and Judge Brue received from the bike shop and the police on Mackinac Island. During her July 2020 statement, Judge Nance mentioned the command and went on to discuss for approximately 3 pages the way that such a command made her feel. Judge Nance stated that she felt an overwhelming sense of dread, that she could envision Black people standing at the curb with horses while white people were inside at the business. Judge Nance further stated that she and Judge Brue discussed the feeling that they were being treated like 2 runaway slaves. This explanation was meaningful to the racism claim that was being conveyed. Yet at the hearing, Judge Nance testified that there was nothing improper about being told to wait by the curb, that it was a normal police command. This is a striking reversal. What was once evidence of racial indignity became ordinary police procedure.
If you were to read my sworn statement, which I hope all of you have done, I absolutely acknowledged in July of 2020 that there were reverse allegations of assault. Piece of paper, rental receipt, happened to belong to Judge Brue. She took it out of her bag. There was this interaction over this paper receipt, and at the end of that interaction, the paper receipt was ripped, and I said to the commission, the investigators, that at the end of that, they both were accusing each other of assault. Judge Brue said, "I feel like you assaulted me," and Mr. Green said, "You assaulted me." I used the words that Hardy blew us off. Blowing someone off, that colloquialism, does not mean that they didn't stand in your presence for 10 minutes. It means that I felt by Officer Hardy that I was not seen, that I was not heard, and the few statements that I made to him, he didn't really appear to be engaging with me. As I stood on Mackinac Island, the land that time forgot, where there are no cars, no traffic, there's just the clump of horses, I said to her that I was having a recollection because I couldn't move. I knew I couldn't move. Direct command by a police officer in uniform. If I had even tried to move, I could have been charged with resisting and obstructing. Because I had to stay there, and I had never had that experience before in my life, where I have not been able to walk about freely, where I have not been able to move, where I've not been able to stand back out of the shade, I expressed to Judge Brue privately how I felt in that moment of being detained. And I see video every day in my courtroom, and the words "stand at the curb" are often used. That's protocol for police officers. But I also know that the next step after their investigation is that you're either going to be told, "Okay, we've looked into it, we've resolved it, you're free to leave," or you're coming with me. I have never been that close in my life to being arrested, and I had never been detained. And so I'm giving her my present sense impressions of not watching cars and vehicles, but watching horses go down the street, a dusty road, there's horse dung, I can't move, I'm in the hot sun, and I get this present sense recollection of what it must have been like for my ancestors 200 years ago while waiting with the horses. There were horses in front of me. What it must have been like not to be able to move. That is when I pulled out my phone and called 911. I wanted to have a supervisor at the scene. I wanted another set of eyes. That's what I've been told you do. The standing at the curb, that's police language. I hear it weekly. I had never been told to stand at the curb. That's what told me I was being detained.
It was about escaping
Yes, I said that. I had all of those impressions. When Officer Hardy turned to me and said, "Get out," there is absolutely no reason on God's green earth that I would risk my reputation, my good name, and my livelihood and a job that I love to go in and intentionally make a false statement to the Judicial Tenure Commission.
For all of these reasons, disciplinary counsel respectfully requests that the commission first reject respondents' affirmative defense of racial discrimination. Second, find that disciplinary counsel did not violate any rules of confidentiality. Third, find that the evidence proves the misconduct as charged in the complaint. And last, recommend that the Supreme Court remove Judge Brue from office. Disciplinary counsel appear before you to request that you recommend the removal of Judge Debra Nance from judicial office. This case, stripped to its core, is not about a bicycle rental dispute. It is not about a misunderstanding on Mackinac Island. It is not about imperfect memory. This case is about lying under oath repeatedly. It is about a sitting judge who, under oath before this commission, knowingly denied facts that, as it turned out, were captured on video and whose story has continued to evolve, retract, shift, and reshape itself over 6 years. These factors weigh heavily toward removal. The public must believe when a judge raises her right hand and swears to tell the truth that the oath means something. If a judge can deny what is plain as day on video, tell the same false stories as another judge, maintain those denials for years, modify them only when forced, and implausibly characterize that evolution as refreshed recollection, then the oath loses its meaning. Judicial authority depends on credibility. Credibility, once lost, cannot be selectively restored. Removal is not punishment. It is protection. Protection of the integrity of the judiciary. Protection of the public's trust. Protection of the meaning of the judicial oath. If persistent dishonesty under oath does not warrant removal, it is difficult to imagine what would.
I've looked forward to this moment for a long time. I'm not happy to be here today, but I've looked forward to an opportunity to address this body. I stand before you today like any other citizen with a constitutional right under 28 U.S.C. 1654, Section 1564, to represent myself. I made an appearance in pro per on November 1st, 2023, pursuant to the court rule at MCR 2.117. My attorneys here, are here today. I'm happy that they've joined me, Mr. Nicholas Serino, Mr. Michael Cafferty, who are seated, who joined me today for support. However, I remain in pro per. I firmly believe that I cannot stand up for the rights of anyone in my courtroom if I cannot stand up for myself. And believe me, I am well aware of the often repeated axiom, a man who represents himself as a fool for a client. Aware. I recognize that standing here before you today may be considered by some to be foolish, even risky, but I want you to hear directly from me.